Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly podcast show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinsky, the former practice group leader for 25 years and the founder of the Consumer Financial Services Group at Ballard Spahr. And I'll be moderating today's program. For those of you who want even more information, don't forget our blog, which also goes by the very same name as our podcast show. That is Consumer Finance Monitor. We've hosted our blog since 2011. When the CFPB became operational. So there is a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. We did about 20 of them last year. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspar.com. And if you like our podcast, please let us know about it. You can leave us a review on whatever platform you're using. And if you have any ideas for other topics that we ought to be covering or speakers that we should consider inviting as guests on our program, please let us know about it. So let me tell you what we're going to talk about today. We're going to focus on what I consider to be one of the most significant developments in New York consumer protection law in decades. It's the shorthand title of the statute is called the New York State Fair Business Practices Act, or even shortened more, the FAIR Act. And that's short for Fostering Affordability and Integrity Through Reasonable Business Practices. And as I said, it represents really the first major overhaul of New York's core consumer protection statute in nearly 50 years. It was enacted in December of 2025, and it's taking effect on February 17th of this year. For decades, New York General Business Law Section 349 focused primarily on deceptive acts and practices. The FAIR Act dramatically expands that framework by expressly prohibiting, in addition to deceptive acts and practices, unfair and abusive business practices, aligning New York more closely with the Federal Consumer Financial Services Protection Act, which is the statute under which the CFPB is governed. Our discussion today will focus on what changed in the law, why it matters or should matter to you, and how the AG's office expects to use this new authority in practice. So I'm very pleased to be joined by two guests today from the Bureau of Consumer Frauds and Protection in the New York Attorney General's office, both of whom were deeply involved in the development and implementation of the FAIR Act. First of all, I'm pleased to introduce Jane Azia. Jane is the chief of the New York Attorney General's Bureau of Consumer Frauds and Protection. She's spent the vast majority of her career in the consumer protection enforcement area. Prior to her recent stint at the AG's office, she was Director of Consumer Protection at the New York State Banking Department, where she oversaw compliance with consumer protection laws governing financial products and services, and worked to ensure that consumers were treated fairly and not subjected to predatory practices. Earlier in her career, Jane served for nearly 25 years as an assistant attorney general in the consumer and internet bureaus, handling a wide range of matters, including predatory lending, financial services, advertising, retail sales, healthcare, insurance, telecommunications, privacy, online services, and product safety. And even earlier than that, she spent 5 years as a legal services attorney in Brooklyn, New York, and in Poughkeepsie, New York. Jane played an absolutely key role in the development and implementation of the FAIR Act and brings to our program today unmatched institutional knowledge of how New York's consumer protection laws have evolved over the years and how this new statute will be enforced going forward. I was very fortunate to meet Jane when she was a speaker at the Practicing Law Institute's annual Institute on Consumer Financial Services Law, which I founded and co-chaired for 25 years. And Jane has been a speaker on that program more times than I can count. So Jane, a very warm welcome to you.
Thank you, Alan. I'm really pleased to be here and have the opportunity to speak to, industry practitioners, because we don't often get that opportunity. And even though we have personally been on the other side of the fence, I think it's great for us to be able to explain how the new law came into effect, why it came into effect, and to the extent we can, how we're going to be using it.
Yeah. And by the way, while we do probably the majority of the people listen to our podcast show are industry folks, a good many of them are consumer attorneys and plaintiffs, class action lawyers, and government lawyers. So you'll really be talking to a very broad audience of mostly lawyers, but not entirely, who are really focused on consumer finance. Let me introduce your colleague. I haven't known until recently. I want to welcome Alec Webley, an Assistant Attorney General in the Bureau of Consumer Frauds and Protection. Alec has served in the AG's office for about 4 years with a focus on legislative, judicial, and regulatory reform. Prior to joining the Bureau of Consumer Protection, he clerked for the now Chief Judge of the New York Court of Appeals, which most of you know is New York's highest court. And prior to that, he clerked for a federal district court judge. He's also been in private practice, complex commercial litigation. Alec was the point person from the AG's office involved in persuading the legislature to adopt the FAIR Act. And as I said earlier, making it the very first expansion of the AG's Consumer Protection Authority in about 50 years. Today, Alec is involved in investigations and litigation applying the FAIR Act's new prohibitions on unfair and abusive practices, giving him a hands-on perspective on how this statute is already reshaping enforcement and compliance expectations. So, Alec, a very warm welcome to you.
Thank you very much. Great to be here.
Okay, so I've got a lot of questions for both of you. I guess you're not surprised about that. But we're going to begin with some foundational questions, and we'll build from there. So, Jane, to set the stage for our listeners, what gaps or limitations in the prior New York law, I guess it was Section 349, led to the consideration of and then the enactment of the Fair Business Practices Act?
Well, I'd have to say that in New York, in the Attorney General's office, we've been trying to get specific unfairness authority added to the statute. I think there are 47 out of the 50 states that already have unfairness, so we were really behind in that sense. And it's something that the Federal Trade Commission has been applying for decades. They have explicit authority. And more recently with the CFPB, since over a decade, they've had unfairness authority. So that has been something that we have wanted to augment our authority about deceptive practices. Abusiveness is something we've modeled on the Consumer Financial Protection Bureau. and they've established a track record of enforcing, what's abusive. But now we're seeing, as we all can see, there's a retrenchment in what the Consumer Financial Protection Bureau is doing and what enforcement actions they'll take. And it's more important than ever that we're able to protect the people of the state of New York. Deception isn't always enough. There can be unfair and abusive conduct where there's the disclosures are made, but they're obscured. There's high pressure sales. They're taking advantage of vulnerable consumers. There's asymmetries between a seller or a lender and the consumer. So these are some of the gaps that the new authority gives us to address.
Right. So you probably have already answered this in relation to the first question, but at a very high level, how does it change 349 compared to the law businesses and practitioners had been used to? I mean, you mentioned it adds unfair and abusive practices, but let me ask you this. You pointed out that the CFPB is going through a period of retrenchment. That's probably a common way to put it. It's not very active right now, performing any of the functions that it's required to perform. It's supervision, enforcement, and promulgating regulations. But I do know that one of the things is agenda, and I think it was mentioned in its semi-annual agenda that got issued a few months ago, where it mentioned 24 regulatory items. And one of the things that it's focused on is UDAAP, or unfair and abusive acts and practices. So before this year is over, we may have different rules, different definitions anyway, what those terms mean. Is New York law require you to sort of slavishly follow what CFPB does, or can you basically define it in the way that you think makes sense, and maybe how the prior leadership of the CFPB defined it?
I'm going to punt that on the deference that we give to what happens at the federal level, but as I would say, as a general matter, that we're not obligated to follow. We have already been looking at what the CFPB has done and some of the things that they have done, and don't, in many cases haven't found that they have a reasoned basis for making changes that they've made. The first part of your question,
yeah, yes.
I think most people, in businesses are very familiar with the Federal Trade Commission and what's, unfair practices. There's been a 10-year record from the CFPB on what's abusive, so I think that also gives guidance. And we are basically following the definitions that have been used by the federal government.
And I mean, the definitions are in the the Consumer Financial Services Protection Act that created the CFPB. They define it, not with a lot of specificity, but in a general kind of way. And I guess that is probably, what New York law was based on.
Yes, it was. But our law, the FAIR Act, the amendments to general business law sort of expanded the universe that would be subject to these provisions. So the Consumer Financial Protection Act is limited to financial services businesses. Our law applies to all businesses, all business activities that occur in New York or that affect New York consumers.
So, yeah, in that sense, it's quite a bit broader than the CFPB, and I guess to some extent, the Federal Trade Commission's consumer protection jurisdiction.
I think we're following its definition of unfairness, but I would make a point that many states have a much broader definition of unfairness, and they don't adopt the Federal Trade Commission standard of unfairness, which is, weighs the benefits against the harms. And many states apply the old standards of the Federal Trade Commission, which are things like immoral or, against the public interest. So ours is we have abusiveness, but our unfair, and both abusiveness and unfairness parallel the federal statutes. But we don't go as far on unfairness as many states do.
Yeah, got it. So, Alec, I was going to ask you to define these terms, but I think we may have already done it, unless you want to add anything to what Jane has already said.
So I would add one thing about the federal question, which is would really encourage folks to look at the text of the statute very carefully, because every word really was labored over in this process. And one thing to note there is the statute expressly says, copy the FTC definition of substantial injury. And that was in part motivated to be clear that we were talking about an injury of substance rather than setting up a comparison with the private right of action. But importantly, with that clause, it's not just what it includes, but what it leaves out. It doesn't say copy the FTC definition of all the rest of the terms. It readily could have, it doesn't. And so I think when you look at New York State statutory interpretation standards, the Court of Appeals has clarified this just a couple months ago, you look at what the legislature was looking at the time it passed the statute and what it was intending to do. And I think, as Jane has already mentioned, we were looking at the decline of the CFPB and trying to redress the decline of the CFPB. And so I think it's going to be very relevant, especially in consumer finance, what the CFPB was doing before the act was passed. But I think that the text, the text is quite clear in not lockstepping us to what it does subsequently, which it readily could have done, and the legislature did not choose to do that.
Right. Now, just related to these definitions that there have been added, new terms that have been added to the statute, will the AG's office be providing any written guidance about the FAIR Act in general, either these two new terms or anything else in the FAIR Act, by issuing a regulation or any kind of guidance in general? Or will it be necessary to basically take a look at lawsuits and settlements that the AG enters into after the law becomes effective? I could throw that question to either one of you.
Well, we have no regulatory. The Act does not give the Attorney General rulemaking authority, so we have no plan to issue rules. Whether or not we'll do some guidance, I think we don't have current plans to do that, but we want to get the word out about it. So we're leaving ourselves open and flexible, and are glad to have opportunities like the one provided by your podcast to discuss the scope of the new law. But I think, as we're saying, there's a lot of existing precedent out there from both the FTC and the CFPB about how these terms will be interpreted.
Yeah, well, and that's a nice segue into my next question, Jane. And that is, since the CFPB became operational, I think the key date was July 21, 2011, there was included in the federal statute creating the CFPB, Section 1042, which gave state attorneys general the right to use certain enforcement authorities that the CFPB was given, namely the full UDAAP authority, unfair, deceptive, and abusive. Did your office ever rely on that authority previously? And I'm wondering, in light of that authority, what does the FAIR Act provide that you didn't already have by virtue of what was in the federal law?
Well, I think there are two things, and Alec can supplement me. The CFPA only applies to financial institutions, and this gives us broader authority over non-financial institutions. So that's one thing. And I think we were limited with respect to national banks. And the state law does not limit our authority to enforce the law with respect to national banks, because FAIR Act is a law of general application. We're not regulating banks, so we're not preempted from using that law to bring enforcement actions as appropriate against national banks.
Right. One major change, and I'm turning now to the question of enforcement authority and turning away from the adding of the unfairness prong and abusiveness prong. There was eliminated the historical focus on, quote, consumer-oriented, unquote, conduct for AG enforcement. What does that mean? Does that mean that you can go after B2B conduct, that is businesses that are treating other businesses unfairly or abusing them or deceiving them? Is that the main change there?
So I think I'm glad you brought that up because I know there's some confusion on that point. So the statute as passed by the legislature is not the final statute that will become effective. There were chapter amendments that they're called here, changes that the legislature made in agreement with the governor that have gone through, that are now almost through the legislative process. And those bill numbers, just so that you have the receipts, it's Assembly Bill 9444, Senate Bill 8811. And what those chapter amendments do here is they remove any mention of the consumer-oriented doctrine. And so the law that will become effective on February 16 leaves the consumer-oriented doctrine exactly as it found it. The governor explained in her approval memo, absolutely no change to the doctrine anywhere in any fashion. It's exactly as it was before we even started talking about the FAIR Act. And, in some ways, I think it's important as well to push a little bit back on this framing of the historical focus for the AG's office. There's never been interest in our office in moving from our focus on consumer-oriented conduct. If I wanted to litigate B2B decisions, I would have stayed in private practice. I joined the Consumer Frauds and Protection Bureau to focus on consumer-oriented conduct. And I know that's true of all of my colleagues. So if you look at the case law, the Court of Appeals has never raised the consumer-oriented doctrine with our office's enforcement, because most of the time, often parties don't even raise it because, of course, it's consumer-oriented. We wouldn't be doing it if it wasn't. Where we ran into difficulties in the last couple of years is our effort to protect a particular category of consumers, which is small businesses. And what we had encountered was some cases where the courts had said, well, these are not conventional consumers. They don't fit into some definitions of consumers, so that isn't allowed. And the Court of Appeals in the case of Himmelstein versus Matthew Bender, we think really correctly said, well, that was a wrong turn. And small businesses can be consumers. In that case was about a law firm buying books they said were deceptively marketed. And the court said, well, this is a business, yes, but they're essentially in the same position as a consumer. And Judge Rivera said, small businesses are just another class of consumers. And that's consistent with the Federal Trade Commission's view for many years that, again, there are postures in which businesses can be in consumers. So the three big takeaways are here. One is that, in fact, the final version of the law doesn't touch the doctrine whatsoever. Two, the doctrine, as stated, allows for actions to be brought on behalf of small businesses in their form of consumers. And three, we're still the Consumer Frauds and Protection Bureau. We are in the business of doing consumer-oriented enforcements.
I get it. Yeah. Well, thanks a lot, Alec, for that clarification. Let me ask you, and I meant to ask either you or Jane this question beforehand. Does this, in addition to now having the full UDAAP authority, does your office have the authority to go after companies that are violating federal consumer protection laws like the Truth in Lending Act and the Fair Credit Reporting Act and Equal Credit Opportunity Act, et cetera, et cetera? Does it Is there authority either under state law, or are you able in that instance to use 1042 of Dodd-Frank?
Well, I think there are a few answers to that question. I know we're here today to talk about the FAIR Act and General Business Law 349, but we have another statute that's unique to the Attorney General. It's New York State Executive Law 6312, and that gives us the authority to bring enforcement actions whenever there's repeated or persistent illegal or fraudulent conduct, and that illegal prong covers federal, state, or local laws. So that is one source of our authority. We can continue to bring cases, under Dodd-Frank, so we can continue to do that. There are certain times when a violation of a federal law may also constitute a deceptive act or practice. There are three possible ways of approaching that.
Yeah, well, I mentioned that because that's I think it's important for people to recognize that even though the CFPB seems to be out of the enforcement business at present, that is, just about all the cases that were pending at the end of Rohit Chopra's term have settled or been dropped. That doesn't mean that there's some kind of moratorium on enforcing federal consumer protection laws, because your state can do it, and many other states have laws similar to your executive law that you mentioned that give state AGs the authority to enforce federal law. So I think that's something very important to keep in mind. Let's turn now to what are the remedies that you can seek. And I don't think anything changed under the FAIR Act in that respect, but maybe I'm wrong. So the question for you, Jane, is what's in your arsenal, I guess is a crude way to put it.
I don't think the remedies have changed. We get injunctive relief, we can get restitution, we can get penalties, and because the statute is essentially an equitable statute, I believe we can also get disgorgement. And these are the same remedies that we can get under our other major enforcement statute, Executive Law 6312. It clarifies, although this was probably an unnecessary clarification, that we can bring claims under general business law as special proceedings, which is an expedited process for getting relief. It kind of combines, bringing it action by complaint, but with summary judgment. And we've always had, and so it's just sort of a technicality. We've always been able to bring general business law claims under Executive Law 5312, which allows us to bring a special proceeding. So this just clarifies that we can also bring special proceedings on this expedited proceeding to enforce violations of the general business law.
Is that similar to just getting a preliminary injunction in ordinary litigation, or is it a little bit different?
There's similarities, but essentially it lets us get to the bottom line. It allows us to go into court with evidence and get a summary determination, a judgment, not just a preliminary injunction. Actually, a summary proceeding is supposed to happen very quickly, on 5 days' notice, so you theoretically don't even need a preliminary injunction. And there are some differences in the standards.
So you could, if somebody was engaged in some massive scam, you could go right in right away and essentially shut them down.
Theoretically. It doesn't always work that way, but theoretically, yes.
I would jump on just 2 points. So one of them is a recent amendment. It's not the FAIR Act, just happened about 1.5 years ago, that I think is important to stress, which is the standard civil penalty for violating 349 is $5,000 per violation. But the legislature has now provided that if you violate 349 during a disaster, an abnormal market disruption, the penalty increases to $15,000 per violation, or 3 times restitution. So to take the recent snowstorm as an example, if someone was engaging in deceptive or unfair conduct during the snowstorm, they would potentially expose themselves to an enhanced penalty of $15,000 or 3x restitution.
I get it. So to use your example of the snowstorm, somebody was out there selling shovels, ordinary shovels, at $100 a piece. You could conclude that that was unfair or abusive, taking advantage of the situation.
So we already have a price gouging statute that focuses on that. But I suppose to change your metaphor slightly, if they were selling shovels that actually didn't work, the shovels they just broke the moment they touched snow or they melted, then, or I don't know how it would melt when it touched snow, I'm just making it up, dissolve when it hit water, then that would be a deceptive practice. And yes, that would attract enhanced liability.
Okay, well, let's talk now about a subject that comes up very frequently when I have discussions with clients about the extraterritorial impact of the New York law. And I'm not talking specifically about the FAIR Act, but the statute, in the Consumer Protection Statute in general. Certainly, it applies to New York residents as I understand it. Does it apply to New York residents only when the harm occurs in New York itself? Or what about a New York resident who travels into Connecticut, takes his or her car into Connecticut, and is somehow defrauded or treated unlawfully by a company in Connecticut that doesn't have any connection at all to New York? In other words, does your consumer protection, follow New York residents wherever they may go?
So the statute actually clarifies this issue because we run into some challenges here. And the gloss I put it is, if you do business from New York or in New York, the statute applies. So let's start with from. You're a New York business and you have defrauded consumers in, let's say, Virginia. Because your business is in New York, you are subject to the statute and we can recover on behalf of those Virginia consumers. And conversely, if you're a Virginia business and you are defrauding New Yorkers, we can sue you and get recovery on behalf of New Yorkers. And the critical piece here is, if you're a Virginia business and you are defrauding people in Connecticut, that's where we sort of don't really play a very big role. And the reason that we wanted and we were persuaded the legislature to adopt this is because it's very common in state AG investigations where you have a business that is going and affecting residents in multiple states. We had a big issue, predatory roofers crossing borders up in New England. And they'll have victims who are in multiple states. And the general rule has been, if you've got a business, if you're the AG taking the lead on this investigation, you will seek restitution for everybody who your home state business has been defrauding. And so Virginia AG will make sure New York people who are defrauded get their checks. And we needed, as New York, to be able to do the same and say, okay, you're Virginians, we're taking the lead because this business is in our state. We want to make sure that the victims in Virginia, get checks. So it really is an effort to just ensure that, interstate comedy in situations where liability is clear, and we just need to make sure that everyone, across the country is getting, what the court has already adjudicated they are owed.
So I would add to that, because I just want to address the example you gave. A New York consumer goes into Connecticut and is defrauded in Connecticut by a Connecticut business. Would our law apply? So I want to say, as a general matter, if that's the pure scenario, no. But if there was conduct in New York that led to the consumer going into Connecticut, there might be a different answer. So I want to just...
like advertising, if the Connecticut...
Advertising and luring them out. And there has to be conduct in New York. In that scenario, there has to be conduct in New York.
Right. Well, when you say conduct, would you include in there communications through the internet or telephone or mail? Do you look at that broadly, or do you mean that there has to be some kind of physical to New York through an office? Or
I'm looking at the former. Are there communications? Are there solicitations? Are there advertisements? I can't definitively give you all the criteria, but we would look at that. That would be a factor.
Not that this is germane to your New York law at all, but several years ago, I was representing a company that was engaged in payday lending based out of Illinois. They had offices in Illinois, but people from Indiana would cross the border. Indiana didn't permit payday lending or the kind of interest rates that were charged. And people would drive their cars from Indiana into Illinois, apply for and get granted a payday loan, and litigated that issue. We claimed that Indiana didn't have jurisdiction over our client, and the case went all the way up to the Seventh Circuit, and we ended up prevailing on Commerce Clause grounds that there wasn't enough connection. Our client didn't have sufficient connection to Indiana to be, in effect, prosecuted by Indiana law. So there is, and I know some cases, if there's a case in Pennsylvania that comes out the other way involving the Pennsylvania Attorney General, it gets very fuzzy when you start dealing with the Commerce Clause. I do know that.
I think you have to really look closely at the factors in each particular case.
Yeah. So you mentioned a little bit earlier, Jane, of banks, and I wanted to just clarify that. So in terms of jurisdiction, I take it's your view you can proceed against national banks, regardless of where they're located. They could be chartered in New York State, but they could be chartered in some other state, or state chartered banks, regardless of where they're located. That you really treat them the same as a non-bank. There's no distinction.
For general deceptive practices, the general deceptive practices law, I think that's correct. But if it's a law of general application, as these laws are, I think it applies to banks, non-banks, everyone.
Yeah. And now, if you're a national bank, there's certain federal preemption arguments that can be made under the Dodd-Frank Act that's got preemption language in there defining when state law is preempted. And that is another very fuzzy area right now, very unsettled because of the Supreme Court opinion in the Cantero case and their cases in the First, Second, and Ninth Circuits that are dealing with that issue. And the new comptroller of the currency has weighed in recently. It's another area that's very, very fuzzy. So let's talk about practical application of your new authority. I know you can't talk about, I'm not asking you about ongoing investigations. And of course, the FAIR Act is so new that you haven't brought any lawsuits yet. But are there, just looking now from a broader, higher level perspective with what's going on with the CFPB and the lack of enforcement there, they're no longer, I assume, partnering with state attorneys general anymore like they used to. Are there particular industries or practices that your office is scrutinizing more closely under the authority that exists already or under the new authority? Jane, I think I'll throw that one to you.
Announcing the passage of this bill, the Attorney General pointed to certain types of practices. They're not exclusive, but student loan servicers steering borrowers into the most expensive repayment plans, car dealers refusing to return a consumer's photo ID until a deal is finalized, nursing homes that routinely sue relatives for the unpaid bills of the resident, companies that take advantage of consumers with limited English proficiency, companies that obscure pricing, health insurance companies that present consumers with long lists of in-network doctors that don't really provide services. So those are some examples. I think it's also useful to look at some of the cases we've already brought. We sued Juul for its marketing of e-cigarettes and focusing on young adults. And a lot of that was just an unfair practice. They were taking advantage of these young adults, not providing any benefits, obscuring the health risks of, the e-cigarettes. We allege that under the Federal Trade Commission Act. We allege that that was an illegality under our Executive Law 6312 for violating the Federal Trade Commission Act. Now we can just bring something like that directly. We've sued a couple of earned wage access providers that provide advances on your wages. But a lot of what they do that's abusive or unfair is obscuring the true costs, hooking people into repeated refinancing of these short-term, small loans, but that add up to triple-digit interest. We also, after the CFPB dropped its lawsuit against Capital One, that lawsuit was based on Capital One having two tiers of savings account. It had its performance savings account, which they represented would yield the highest interest rates, and a couple of years later introduce a new 360 performance saving plans, very similar names, that actually offered a higher interest rate. We said that that was an abusive practice. They were concealing, and obscuring the true cost of these things. And one thing about the earned wage access cases, and I think particularly germane now in an environment of high tech and, all these ads that come over your internet, like the earned wage access companies were constantly shooting consumers. Like, we can give you a boost on your advance. We can give you $5. We can give you $25. Well, technically that might not have been a deception. They were giving those out, but they were acting in a way that was taking advantage of the consumers and obscuring the risks. And so, those are claims that we said were abusive. We were relying on in those cases. Dodd-Frank is an illegality under our state law, but now we can just use our own state law directly.
Yeah. You mentioned the CFPB dropped the case and you pursued it. Are there other situations where the CFPB has dropped cases, and they dropped, I think, maybe 30 or 40, where the New York AG has already filed a lawsuit against the same company? Has that happened yet? I use the word yet because I'm not asking if you're investigating anything.
Well, that was Capital One. We didn't start a new case, and it wasn't, but we did. They dropped a case against MoneyGram for violating the money transfer regulation, and we were a co-plaintiff in that case, and we continued that case. We reached a settlement with MoneyGram. Oh, and another case is against Credit Acceptance Corp., a subprime auto lender. We had been a co-plaintiff with the CFPB, and they dropped that case, and we are continuing that now.
No, I think those are all good examples.
Yeah, but I guess there aren't any. What I thought was going to happen, maybe it hasn't happened yet, but when the CFPB ended up dropping all their cases, there was all that flurry of activity, but during a short period of time, I sort of counseled the clients that that doesn't mean they're out of the woods. It just means the CFPB isn't going to proceed against them. It's possible that any one of the AGs could file a new lawsuit, or that they might get hit with a private plaintiff's class action covering the same thing. But I expected there to be more of that type of thing, but I haven't seen it yet anyway.
Well, I think that was good advice that you gave your clients. I think the states are looking at the issues that were raised by the lawsuits that were dropped.
Okay. So we're sort of drawing toward the end of our program, but I have a few additional questions I want to pose. First of all, you mentioned that you were co-plaintiffs with the CFPB in a few cases before the change in administration. Sure that you collaborate with other AGs in certain cases and multi I forgot, well, when you network with them and you bring lawsuits, that's very common. I assume that's still going on. I'm wondering if you could comment on that. And then I'm wondering, to what extent does your jurisdiction overlap with DFS, New York DFS, I guess formerly called the Banking Department? Are there areas where both of you have jurisdiction or where you collaborate with them? And then now you've got the New York City Department of Consumer and Worker Protection, led by Sam Levine, a alumnus of the I don't know if it was with the CFP, the Federal Trade Commission. And they've announced that they're going to get involved with junk fees and also subscription plans that they consider to be unfair. Tell us a little bit about the extent of overlap between the other New York agencies, DFS, New York City, and the extent to which you're partnering with other states or the Federal Trade Commission. I know you're not doing anything with the CFPB right now.
I think there's a lot of overlap, but there are real distinctions too. Department of Financial Services is mainly an administrative agency. They can't just go into court. We're as the Attorney General, the Chief Law Enforcer, and so they can proceed by administrative hearing, take away licenses. They license many financial services providers. We have in the past collaborated with them on litigation. A few years ago, brought a case against a company that was promising turnover. They were getting consumers to take properties that were really run down and they could buy them back. And there were a lot of problems with this. And we did a joint case with the Department of Financial Services. So we often just operate in our own spheres. We often consult, and we have regular meetings in New York. So we do that with the Department of Financial Services, recognizing that they're a licensing agency and that a lot of what they do is with their licensees. We also have always collaborated, and even more so now under the new administration, with the Department of Consumer and Worker Protection. We also have regular meetings with them. We also try to, in some ways, divvy up investigations. There could be an industry that's problematic and they may be looking at one and we're looking at another. We have, our laws are somewhat different and there are many similarities. They have deceptive practices laws. They have specific regulations. So, in any industry, we may choose one target. They may choose another. They may, take away a license. They may do they may have some other remedies, but we really are trying to coordinate with them. And we don't want to do overkill. We recognize there's a lot of fraud and illegality out there that needs to be addressed. And so we're just not going to keep doubling up on things. We're going to try to communicate. So
Right. And I assume nothing has changed with respect to networking with other AGs. If you've got a company that's engaging in unlawful behavior that affects more than New York, multiple AGs are usually get involved.
There's a lot of that. There are a number of multi-state investigations. And, sometimes we go with the multi-state and sometimes we do our own thing. But, there are various task force in various areas like automobile sales and financing. There's a task force that deals with that.
Right. Got it. So let me ask you this, Alec. What should companies be doing that are affected, they're subject to your jurisdiction and they've heard today about the new FAIR Act and the other authorities that your office has? I take it this is not a time, because of what's happening at the CFPB, to say, well, we don't have to worry about compliance for the next 3 years, right?
So no, but I think that when a statute like this is passed, it's actually a really good opportunity for both in-house and firm counsel to do what clients are always telling them to do, which is be a partner to the business. Because this can provide the business with an opportunity to sort of take a moment from the day-to-day and look at their business practices with a appropriately skeptical eye. And the example I love to bring up here is a case called FTC versus Wyndham Worldwide, which is 799 Federal 3rd 236. It was Third Circuit in 2015. And this was a case where the Federal Trade Commission alleged that Wyndham Hotels had not engaged in very basic cybersecurity protections. And it had led to a hack, and 60,000 consumers' private information had been stolen by criminals. And the Third Circuit said, as pled, that's unfair. And the thing about that case was, of course, as the hotel itself said, absolutely nobody thought it was a good idea or benefited the hotel to not take basic cybersecurity precautions. It was just a case of there hadn't been a moment, before, even after the first hack, where the leadership and their lawyers have sat down and said, okay, we've identified a vulnerability, we've identified a problem, let's spend some time and energy thinking about how to fix it. And so, what I would say to businesses is take a look at your consumer complaints, because if they're complaining to us, they've almost certainly started off by complaining to you. See what they're complaining about, and then ask yourself really critically, is this something the business really needs to do? Or is this something the business could fix that would make their customers happier and address this problem? Because I think so often we find, when we've got through an investigation, is the business realizes, actually, we never really needed to do this. I think there's a lot of that low-hanging fruit that a lot of businesses can do, and a lot of lawyers can work as real collaborative partners in coming up with something where it ends up being that even without the law, the business was better off changing their practices.
Yeah. Let me ask you as a follow-up to that. If a company were to come to the New York AG and say, I'd like to sit down with you and describe, let's say, a new product that we're thinking of launching, but we're a good corporate citizen and we want to make sure that we don't say anything wrong with this product, but we want to make sure you're comfortable with it. Is that something that you would entertain?
We'll always talk to a company, but we're not going to be able to sign off on any, this business plan. And, we don't know how it's going to play out. We can't, they have lawyers who can give the advice. We're not going to give a stamp of approval to anything. That's just something we cannot do. But to add on to what Alex said, companies should just be looking at what do they think? Are these practices fair? Are they taking advantage of vulnerable people? Are they obscuring key information? Are they hiding information about the costs and the risks? Those are the kind of things I think they can do on their own. I think every company wants to avoid an enforcement action on things that are just, bad practices.
Yeah.
It's not good for business.
Over the years, when clients ask for advice on something and it's in somewhat of a gray area, whether it's legal or not, and I'd say to them, how would you like it if there was a front page article in the New York Times or the Wall Street Journal about your product? Would you feel comfortable then? Very often that brings out areas of discomfort. And I said, well, if you're uncomfortable with that, then you ought to back away from what you're doing. That's my old litmus test. So as we're drawing toward the end, I just have one more question about substantive question. Then I'm going to ask both of you, just looking ahead for the remainder of this year, maybe into 2020, where you think things are headed. But I want to ask you about AI. That is, of course, that's what's happening everywhere these days. Every company is getting into AI. Is that a focus of your office as well? Or do you leave that for the banking department to deal with things like that? And I recognize your jurisdiction is a lot broader in the sense that you cover all kinds of consumer, sales of goods. It's not just financing.
It's definitely an area of focus for our office. I would say that our office has developed a lot of specializations, and probably the AI issues are handled more directly by our Internet Bureau. But it's definitely, I can tell you that it's a huge emerging issue.
Yeah, well, and I guess used to, when you were working in the Bureau, in the Internet Division, I guess there was no AI back then, right?
That was in the late 90s, so a long time ago.
There was barely an Internet.
Well, barely, AOL was dial-up.
So now I'm going to ask you to look into your crystal balls that you each have on your desk, and where do you think things are headed in this area? Let me start with you first, Alec, and then we'll go to Jane.
Well, I think that, in respect to this statute, one of the big things that we've done in New York that's very different from other states is we went to the trouble of defining in very clear text what unfair and what abusive is. And so, I'd like to hope that when you start seeing our enforcements under this statute, you're going to read, the allegations in our petition, and you're going to say, okay, I can see how a reasonable person would see those facts and say, yeah, that fits into those statutory words. So, we had a lot of concerns, I think, that we heard over the course of the year about, these words seem very broad. These words seem very, we're worried about how they can go. And I feel pretty confident that, in the coming year, you're going to see stuff that's like, yes, that's right down the fairway of what these words mean. Because, we labored over those definitions a lot, and we think that it's, the text here is really important. We want to be very, faithful in adherence to the text, recognizing that it is a broad text.
Right. Okay. How about you, Jane?
Well, I think you're going to see, we've always tried to act in the public interest. That's what we see our role here is. And to protect those that are economically vulnerable for one reason, whether it's, their economic levels, their language, abilities. We're also going to focus on, there's a lot of use of, we have so much technology and there's so much advertising and solicitation, on, your iPhones and on your computers, and that can actually be quite abusive in the way things are marketed. And there's a lot of fine print on a little iPhone that you just couldn't possibly ever read. And those are kind of things that we're going to pay attention to, the emerging technologies, or that whatever the technologies are that are used and how they may take advantage of consumers.
Subscription plans, I guess, would be one area, right?
But almost everything you sign up for now has, you scroll on and on and on, and everybody knows nobody reads that. But I mean, you probably don't even read it. All that.
And I would put two minor points on top of that. First, I would just caution, in New York civil procedure rules, when fine print gets too fine, it becomes inadmissible in our courts. There is anti-fine print law on the books. And that is the print as it appeared to the consumer. So when you've got 3-point font on a phone, be very cautious in assuming that a court will be even able to admit that contract.
Yeah. That's been law for a while, am I right?
Yeah, for many, many years. And it's an area of active interest in the legislature. And the second thing I would say is, if you're considering hiring a psychologist to determine how to hack the attention of your customers, you may want to consider that spending.
Right. Well, Jane and Alec, I want to thank you both for such a thoughtful and practical discussion. Your insights into how the FAIR Act was developed and how it will be applied are incredibly valuable for anyone trying to understand what the New York law really means beyond the statutory text. So again, my thanks to both of you.
Thank you very much.
Yeah, and you're always welcome back to talk about new developments as well. As we wrap up, a few takeaways I want to give our audience as I can glean them from the show that we just did. And that is that the FAIR Act marks a very fundamental shift in New York consumer protection law, expanding the focus well beyond deception to include unfair and abusive conduct. Second, it significantly strengthens the New York AG's enforcement authority, giving the state new tools to address modern marketplace harms that previously may have fallen outside traditional doctrines. And then third, with the effective date of February 17th of this year, businesses operating in New York should be taking this moment very seriously, reviewing practices, reassessing compliance frameworks, and understanding how broad statutory standards may be applied in real-world enforcement. This law is about fairness, transparency, and accountability in the marketplace, and its impact will be felt well beyond New York's borders, as we discussed. Jane and Alec, thank you again. Thank you to our listeners for joining us, and we'll be continuing to track what transpires in New York in the months and years ahead. So with that, my thanks to our audience, and I hope everybody enjoys the remainder of their day.